This is Brent Allan Winters, commonlawyer.com, and this is part 5 of our series on the question whether or not the Constitution of the United States is biblical. Some have even said, and now say, that it is an Antichrist document written by men that were Antichrist, men that were in the process of trying to subvert the Word of God. And I hasten to add that in the face of those accusations, and against those particular accusations and such other like accusations, I don't quarrel. And as I've said in our other presentations prior to this 5th one in the series, because we are a government of law and not of men, it is and can be, I should say, immaterial whether or not the men that put together the Constitution, and I call them the immediate cause of the Constitution because the people of the United States are the prime movers and the ones that inevitably and most assuredly did demand that something be done. In other words, there was in that day, back in the 1780s, a critical mass of Americans in the Confederation of American States at that time under the Articles of Confederation that saw that forces in the world at that time were threatening them. And chief among those forces were the Bank of London and Britain itself, and of course Britain at that time was controlled exclusively by the power of those men that held shares in the Bank of London. And the trading arm of the Bank of London was the East India Company. And the Bank of London had bought hook, line, and sinker the whole idea of mercantilism, a doctrine that says the only way a country can have wealth is through forces of monopoly control and regulation. And for these very reasons, at heart and at bottom, the 13 American colonies went to war and on fields of battle settled the question, said we don't want to submit to such foolishness. We want freedom to trade with whom we will, freedom to issue our money with whom we wish. We do not want the bankers in London, who by the way were controlled by bankers from the continent, controlling our lives here in America. And by the way, that particular question tells the story of American history since our inception. As Lord Acton put it, and no one knew the subject better, he said that the issue that is between the banks and the people is the one issue that has never conclusively been resolved since the dawn of human history. And even if it is resolved in a country as it was in this one, the Bank of London continued its onslaught against America, needling America at every point, pushing, fomenting war, assassination, which was unknown in our country until the Civil War, almost exclusively unknown, because we are a common law country. But we are a government of men, and the nefarious purposes of the evil empire of the evil one and his mindless lackeys, bureaucrats from every level, have tried unceasingly to take over our country through the processes of subversion. That is, subversion of due process. Well, we began with the preamble, and we got into the Article 1, Section 1, Clause 1, which grants all legislative powers herein granted, important clause, and that means that the Constitution of the United States does not grant all legislative power in our country to the Congress. Not at all. Let me read that again. All legislative powers herein granted shall be vested in a Congress of the United States. All legislative powers herein granted. So the limiting clause, the limiting words, the words of limitation, as our common law would say, are the words herein granted. And if you go to Article 1, Section 8, you'll see there listed a finite list of powers granted to the Congress of the United States. Now, to be sure, Congress has abused that reach of power. They began doing it early on. As a matter of fact, before even the turn of the century, within a dozen years of the ratification and putting in place the Constitution of the United States, Madison and others, Jefferson, became extremely concerned, and they drafted two resolutions. One was called the Resolution of Virginia, and the other was called called the Resolution of Kentucky. And those two together were called the Resolutions of '98. And why were they called the Resolutions of '98? Because they were published to the world in 1798, just not quite a dozen years after the ratification of the Constitution. And their concern was this, that those in government were not being careful to limit themselves to the paper barrier that had been set up. Just as the Bible is only good as far as a man knows it and obeys it, and by the way, he cannot obey what he does not know, he must know it. So also the Constitution is good only so far as a person knows it and obeys it. And my theme here is, in this series of presentations, is that the Constitution of the United States is not contrary to the Word of God. You know, in Article 6 of our Constitution, it says that this Constitution, and then it says, and all the legislation and treaties pursuant to it are the supreme law of the land. And the operative words there are pursuant to it, which again, coupled with the words law of the land, indicates due process. No state court in America has any constitutional authority to recognize any law that Congress puts in place, nor any decision that the Supreme Court makes that has not followed due process in its making and conclusion. Now that comes back to a fundamental first principle of the laws of nature and of nature's God. The laws of nature, Blackstone says, the common law, the law unwritten. The laws of nature's God are special revelation as opposed to the general revelation of nature. The special revelation, the law written, which is the Bible. Anything repugnant to those is not law at all. And anything that does not follow the process that God requires of all things is repugnant to due process. And anything that is repugnant to due process is repugnant to our Constitution. If there's anything, the Constitution makes the supreme law of the land. It is due process. And we pointed out, it bears repeating, although I've said it many times just in these few series. Magna Carta's phrase, drafted by Stephen Langton, who was the foremost Old Testament commentator of his day, by the way, who no doubt, I have to assume, understood this Old Testament concept. The word occurs often in the Old Testament. It's translated different ways in our English Bibles, but it always carries the common thread in every use it has. And that common thread is process. Called it the common law due process. Well, Stephen Langton wrote in Magna Carta that everything has to be done according to the law of the land, and there's no question our Supreme Court has recognized that that phrase means common law due process. And so we find that phrase also in our Constitution, in Article 6, wherein it says that pursuant thereof, that is the process, the supreme law of the land, that also is process, speaks of the due process of the common law. And I want to add one other thing, supreme. Supreme, the word supreme in that context is a comparative, not a superlative. Compared to other things, and here is what I'm finally driving at, compared to other laws in America, specifically compared to state laws, the text of Article 6 says where those state laws, and that's what it's referring to there, are contrary in any way. Contrary, the operative word here is contrary. Those laws that are contrary to the Constitution must give way. Now let's make a distinction here between what is contrary and what is in conflict, and these are distinctions that the common law makes, and not only the common law, but the law of good sense. To be in conflict, or to be something we don't understand how it goes together, is not contrary. Contrary means that there are two standards, and I cannot obey both of them at the same time. In other words, if I obey the one, I will violate the other. That means contrary. There are many things that the state laws say to do or not to do, or enforce or do not enforce, that have nothing. There's nothing in the Constitution that pertains to them. They aren't contrary. They may even be in conflict, but contrary is quite another matter. And to bring up one other matter that will bear repeating as I go along, the Constitution of the United States gives legislative power only to those matters the Constitution lists in Section 8 of Article 1. And among those powers is none of what the common law has called anciently the police powers. The police powers. The federal government, or as our early ancestors called it, the general government of the United States, has not the police powers over anything but their own property. In other words, federal lands, as they say, federal enclaves in the Constitution, federal buildings, federal real estate. The federal government has absolute authority over its own property, military bases and installations and dockyards and shipyards that belong to the Navy, belong to the federal government. But the federal government has absolutely no police powers within the borders of the states of the United States. Now that causes a problem. And it's caused such a problem that the federal government has routinely trespassed upon the rights of the states, and they usually do it. They get away with it by intimidating the states into allowing them to do it. They, of course, will threaten to withhold money. They'll even threaten to use force against sheriff's departments, for example. But at any rate, the police powers under the Constitution that belong exclusively to the states within the borders of their states and only to the federal government in the District of Columbia, that area where Washington, D.C. is, of 10 square miles, and on federal property, those are powers that regulate the health, education, and welfare of the people therein. Now we and our parents and our grandparents, and probably now I'm speaking to generations that go back to their great-grandparents and further, have been foolish and negligent in allowing the federal government to overstep its police powers within the borders of the states. It has happened through fear and intimidation, and downright ignorance, and worse than ignorance, stupidity. And I distinguish the two. Ignorance is something we all suffer from to varying degrees on varying points of fact. And we're all ignorant, and we all need to be learning as much as we can, as often as we can. But to be stupid is quite something else. Stupid means thick and slow. That's within every person's prerogative to get up and open up his mind and not be mentally lazy or physically lazy. Thus we and our fathers and our grandfathers and our great-grandfathers have been. We have not rode herd on our state representatives and our federal congressmen and our senators to stop the federal government's exertion of police powers within the states. To the point now, the president, or whoever sits in the White House, call him president if he's qualified, I suppose, but whoever sits in the White House claims the power to assassinate American citizens without permission, without trial, and to jail people indefinitely without the benefit of the writ of habeas corpus, which our Constitution says shall never be suspended. That's a common law right that existed before the Constitution was ever put in place, and it was around for centuries. Well, we've taken a short rabbit trail to maybe say things that will be repeated again, but the idea behind those comments was to emphasize that the legislative powers of Congress are limited to those powers listed in Section 8 of Article 1. And by the way, when a list of things like that is listed in a document, and it's long enough and it's apparent that it meant to list all it was going to list and not just make a representative list of something short of every power that was given Congress, in this case, for example, it is presumed that no other powers are allowed. For example, the Declaration of Independence says that we have certain unalienable rights, and then it uses the phrase, and among these. Well, that means that he's not going to list all of our rights, he's just going to mention 3. But Section 8 of the Constitution is different. It lists all of the powers of Congress, and it's apparent from all that's said there that the intention of those that put that in there, the people of the United States, was that the federal government or Congress is limited to those powers. As is said, these and no other, these and no more. For example, it says Congress shall have the power to lay and collect taxes, to establish uniform rules of naturalization, uniform laws for bankruptcies throughout the United States, power to coin money, regulate its value, to fix standards of weights and measures. And by the way, there are reasons, good reasons for all of these. We'll get into these later. But as to the legislative power and the abuses that occur, this legislative powers clause of Section 1, Clause 1, Article 1 of our Constitution means that only Congress shall legislate concerning the powers it's given. That means to pass laws. That means also that Congress cannot delegate its power to legislate to anyone else or any other branch of government. That means not to the President nor to the Supreme Court. Thus, the President has no lawful power to use executive orders and regulations. Actually, what he's doing when he does that is using these, calling them executive orders and regulations when they're really legislation. They are the setting down of laws that he intends to enforce. Now, we touch here in this Article 1, Section 1, Clause 1, the legislative powers of Congress, and it would pay to mention at this point the overarching, fundamental, biblical, and common law doctrine that our common law calls separation of power. There are only two government systems, two traditions of religion, law, and government in the world, and never have been more than two. And this has been recognized by many people over the years. As Abraham Lincoln put it this way in his debates with Douglas, I think he said this at Charleston, Illinois. He said there are only two ways to look at government. Either you have a government that says you work, you sweat, you earn bread, and you eat it. Or you have a government that says you work, you sweat, you earn bread, and somebody else gets to eat it. The first is a common law government. The second is a government of what is called popularly civil law. These two forms of government, two traditions, have been called over the centuries. One has been called the civil law, which is a Latin word, translates into city law, law of the city, and it came to be known by that name because it was the law of the city of Rome that was applied to all of the territories of the Roman Empire. And Rome had done that, just as Babylon had done that, and Pergamus, and the cities of Egypt. The city law is the law of Rome, and the law of Rome in its two dominant traditional forms, the German form and the French form, one put out by Bismarck and about 1900, I think it was the year 1900, and the other form was put out by Napoleon. He put his name on it, called the Napoleonic Code. These two codes govern almost every country in the world today, and their various forms. They also occur as canon law in the Roman Church, and as a matter of fact, the first university in the world established by Rome, and for centuries gave degrees to those that studied the civil law. That was the purpose for the university, the law of the city, and they gave a degree. It was a dual degree in canon law, the Roman Church, and the Roman Code. Some countries in the world today are governed by the canon law of the Roman Church. For example, Ethiopia has a form of the canon law, but it's not much different than the law of Germany or France or any of the countries in South America because they're all the Roman Code, just tweaked a little differently in a few places to make them apply where they want them to apply. That is the dominant tradition as far as being widespread in the world today. By the way, Islam, in fundamental first principles, falls into that category. If you are interested in reading more about that, you can go to my comparative law text, Excellence of the Common Law. It's available at the website, www.commonlawyer.com, and you can read about that. I trace the history of the civil law, the city law, from Babylon, where it was first organized under a man named Nimrod, on through to Pergamus, down to Egypt, back to Pergamus, to Rome, and then spread throughout all of the world in modern time. In contrast to that, and its ever-present antagonist, is the law of the land. So you have the law of the city and the law of the land. The law of the land is of course, common law, and the dominating feature of our common law is process, not result. And our common law is process oriented. We focus in common law on facts and process. The Roman civil law, the Roman law of the city, the code law focuses on the law, the result. We want the result. The common law is about it's adversarial. We have trials in common law countries. In civil law countries, they don't have trials. They have inquisitions, and it's called an inquisitorial system for that reason. And if you know anything about history, you're familiar with the inquisitions of the Middle Ages. And with inquisitions, of course, comes torture. Due process isn't really a part of it. It's just we want confession, and we want a certain result, and so we'll do anything we have to do to get it and make it look legal. That's what civil law is all about. Now, that doesn't occur all through civil law countries all the time, but the power is always available, and the power does rear, those powers of torture, etc., rear their ugly heads periodically, and we get people like Bismarck and Hitler and the imperial emperor of Japan begin to slaughter, rape, pillage, and plunder other people simply because they have gathered all three powers of government into one legislative body to express one will. That's the danger, by the way, of legislative sovereignty, which was tried in America, and one of the reasons why we put the Constitution in place was to get that balance of separation of powers. Common law government is a government of separation of powers, and each of these powers, these branches of government, are limited. The legislative power we're speaking of here, it is exclusive, our Constitution says, to Congress. They cannot delegate it to someone else, as they did do to Franklin Roosevelt back in the 1930s, and he accepted it. And then Roosevelt threatened to pack the court in order to get the court to agree with him. Well, the separation of powers doctrine has been brought to its pinnacle of separation, more than it has been in any other country, including England, in the American Constitution and the state constitutions that have been fashioned in its own pattern. To allow all three offices, that is, all three powers of government, to gather into the hands of a single will, whether it be a man or a combination of men, such as a legislature, says everyone who's written on the subject who has any sense at all, to do that, or allow that to happen, is the very definition of tyranny. No question. Let's look at it this way. If one man or one group of men can, by their single will, command other people what to do, that's called statutes, legislation, or not to do, I should say also, and then have the power to enforce that legislation, and then on top of that have the power to interpret how that legislation is to be applied in individual cases, is tantamount to idolatry, because it does the one thing that God forbids never be done, and our Constitution forbids it too. Now, whether or not men follow the Constitution is quite another matter, but it is forbidden, and that is the very reason why the kingdom was ripped from the hands of Saul, because he compounded some of those powers. That men don't follow the Constitution, that men had evil intent, or that were imperfect, less than perfect, who drafted and put in place the Constitution, they were the immediate cause of the Constitution. Standing alone is not an argument against it. The doctrines of the Constitution are, as I see them, and we'll continue to flesh this out, and you can make up your own mind, are consonant with God's Word. And again, if you want to see how many ways it's consonant, I have those listed in a chapter in my comparative law book, Excellence of the Common Law. You can get it on the website, commonlawyer.com. But always remember, if there is not a critical mass of people who understands this particular expression of the laws of nature, our common law unwritten, now frozen in words for us to contemplate, if it is not part of your life and understanding, then we will not be free. The concepts of our Constitution, for example, the first principles, such as separation of power, must be understood. All the intricacies of the arguments of the court of the United States are of no consequence compared to whether or not there's a critical mass of people in our country who understand and live and are convicted about the first principles of our Constitution, such as separation of power. Now, if you will indulge me for just a moment, I want to try to make this point that the Constitution, the principles contained therein, the first principles of that document, and believe, by the way, that's all that's there. If they're not part of who you are, who a critical mass of Americans are, we will never realize the benefits of freedom that can arise out of them. Paper rights are worth when threatened, said Justice Jackson of the U.S. Supreme Court. They're worth just what some lawyer will make them worth. Well, if it's not some lawyer, it has to be some litigant, and it could be you. Most people can't afford a lawyer in most cases. And so you've got to know a little bit of something and stand up for your rights as best you can. Because men are inherently evil about those kind of things. They will run over you if you haven't yet discovered that. And when I say men, I'm talking about the bureaucrat-minded people in government. Those that receive paychecks from the government, those that are employees of the government, and those that are dependent upon the government who cheer on those bureaucratic-minded employees. When I was a young fella, we spent a lot of time with animals. Specifically, we had cattle and hogs and course, a few horses, for wild goats, chickens. But for all of those animals, the female of each of those species, determination to protect their young, and they were all very determined. None was more effective, more vicious, more proven that every fiber of her frame proved her launched for one sole issue, armed and engined for the same, that is, the propagation of her species. None held a candle to an old sow. Not only are sows hostile, mobile, and agile more than people realize, they also are extremely determined and tough as any animal can possibly be. Now, every morning it was my job to get up and do the feeding. And usually when I went out, there were hogs that were out of the lots. And hogs are impossible to keep in. Little pigs, big hogs. Hogs have to root to live, and as the saying goes, root hog or die. Hogs root, and that means they root their way under fences. And my father had always taught me, and I remember it well, and it's absolutely true, that if a hog can get his nose through anything, he'll get his whole body through. Stockmen build fences horse high and bull strong, but a pig tight fence is mere cant. It can't be done unless you use solid steel. And we finally got to doing that as time went along. We lived in an oil field, and we were able to get together what we call sucker rods, the rods that go down in the oil wells. They're 16.5 feet long, which is the distance of an English rod, by the way. And that's where I learned how to weld. Welding those rods together, I'd take a cutting torch and cut them to the proper length, design a gate, lay it out on a pallet, and I'd begin to weld the pieces together. And I welded quite a few gates together that way. You talk about heavy. That's the best steel, that probably as good as any steel that was ever made. And it had to be good steel because you attached them together, and if the more you put on attached together to run down into the oil well, by the time you get down to a couple thousand feet, you can imagine how heavy that 3/8 inch steel would get. So they had to be strong, and indeed they were. Well, I'd go out in the morning, all the pigs would be out, and the dogs would go with me. We had some shep dogs, and they were pretty good. They just loved to run those pigs and get them to all go back in the lot. Well, they'd go to work real quick, and some of the little ones I'd try to run down and catch by the hind legs and throw them over in the lot. One morning I went out on the sand hill where we had the lots, and the dogs were worrying the pigs. Pigs were running, and I got in the chase, and I dove for one's hind legs as it took around the fence corner, and I got his legs. We both rolled into the horseweed. He probably weighed about 60 pounds. I got him up, kind of guided him by the back legs. His front feet touched the ground. It was like holding a jackhammer. I got him over to the gate, and it was made of those steel shackle rods. And I looked over in the pen, and there was the piglet's mother. And she was standing sideways to me, and she was working herself into a scrap. And I looked at her udder, and I could tell from what I had learned from others and just being around the hogs, when a hog gets ready to fight or flight, the blood rushes from its udder, especially if it's a nursing sow, rushes from its udder, and it turns white. If it's a Yorkshire, which ours were, and this sow's udder was white. That means the blood had rushed into her muscle, and she was worked up, ready to fight. I had the pig in hand. I wanted to swing him up over the gate, and so I thought, well, she can't do anything to me with this 4 foot solid steel gate between me and her. I'll just swing the pig up and over into the lot, and everything will be okay. So I kind of got myself leaned back on my heels so I could take a half turn and swing him up and use his weight to throw him over in there, which I did. And about the time I was ready to let go of the pig, I had him in midair, had him swung up. The centrifugal force was holding him kind of suspended there in front of me. She'd already made a charge at me. Didn't concern me a bit. I've seen this all before. I've seen them crash into those gates. I've seen them stop short of those gates. Well, this old sow was coming, and I looked toward her. I could actually see down her throat. Her mouth was wide open, and she was screaming and running at the same time. Well, about a few feet from that gate, she did the thing that I didn't think I would ever see her or any other sow do. She went airborne. And as she came up into the air, I did the instinctive thing. I let loose the pig and fell backwards, and she slammed into the side of that pig with her open mouth. Caught him right in the middle. Chomped down on him a couple of times. By that time, I was rolling backwards, of course. I was into the horseweeds, and when I finally looked back, I was trying to save my hide. The poor pig had received a couple of holes in his hide. She had turned him loose once she regained her senses, and she was standing there looking at me. And her energy was spent, and I didn't think she would come after me. I could tell just from the feeling of the animal at that point that I was safe, although I did scramble over by the fence on the other side of the corner. Now, that old sow did the one thing I didn't think she'd ever do. I'd erected a barrier that was between me and her. It was made of the finest steel available. I put it together, by the way, myself. Welded it together. I had full confidence in it. But when passion, listen to that word, passion, took a hold of her psyche, of her soul, there was no telling what she would do, and that barrier that I had erected didn't mean anything. And believe me, the passions of men in government, coupled with their natural ambition, ever impelling them, they will transgress the constitutional limits for government. Those are the people in government. The founders and the people of the United States had hammered out, forged, fashioned the Constitution with great care. And it really was a restatement of what had taken centuries to work out. It had been stated and restated several times before. We cited two examples. The laws of King Alfred the Great, about 800 A.D. Cite another, the laws restated again, the Edward the Confessor. Magna Carta restated again. The reissue of Magna Carta, the English Declaration of Rights, the Declaration of Independence of the United States, as we call it, the Constitution of the United States are statements and restatements of our common law government. But those are barriers made of paper. They're not even as good as the steel gate. Let me sum it up this way. To trust the Constitution in the place of the eternal God of all creation, somewhat as I trusted my gate with that old sow, is legalism at best and dangerous at worst. Don't get any ideas. Mankind, and that includes you and me, Blackstone said this too in the beginning of his commentaries, we are wholly dependent creatures. All that any of us has or hopes to have and enjoy, we must derive from the God that made us. And if therefore one yearns for right government, one must trust God to create the loyalty and instill the steadfastness to claim the principles of the Constitution necessary for keeping government within the boundaries that it sets. Now, it is the principles, the first principles of the Constitution that are important. Constitution is just another, a good one of the best probably, statements of common law of government, setting the boundaries of what government ought to be and ought to do. But never forget, our national motto is not in our Constitution we trust. It is in God we trust, for to trust in anything but God is ipso facto idolatry, and we will suffer the consequences of it. Our freedoms will never be realized. Moreover, we are never to trust those administering government, never to trust those we elect to government, as good of men as they may be in all other respects. They are still wholly dependent creatures, as weak as water, by comparison to God. And by the way, your life will be as safe and successful and right and good as whatever you place your trust into. This is Brent Allan Winters, commonlawyer.com, and next time, Lord willing, we'll begin with part 6 in this series concerning is the Bible Constitution? No, is the Constitution biblical? Is the Constitution biblical?